established practices, including its long-standing acceptance of written testimony and the level of accommodation this committee has traditionally required before proceeding to criminal contempt, not civil, criminal contempt. I'm glad, as the ranking member has stated, that the Clintons have agreed to testimony and to a transcript and to meet. I agree also that that meeting should not be taking place in New York. It sends the wrong reason for anybody that gets something from this committee. They should come to the committee. It's just that plain and simple. But it departs in many instances with the way this committee has moved on. And I say that because we never know this time next year who might hold that gavel and who on either side may want to go after the current president, his sons, his wife, his family, and anybody connected to him as a department head. I'm just pointing out the fact that it's a slippery slope. Now, does Bill Clinton have to defend himself? Absolutely, yes. It is a bit curious, however, why we are going after Mrs. Clinton. I've not seen anything, as the gentleman from Massachusetts said earlier, that suggests that she ought to be a part of this in any way or has done something wrong or is complicit in this matter. And I would hope that there's some consideration, Mr. Chairman, to withdrawing at the very least that particular resolution. It just makes me think that this is a fishing expedition and that we want to dust her up a bit if we get her before this committee. Now, a couple of quick things. We're being asked to move forward holding a former president of the United States, again, not in civil contempt, in criminal contempt of Congress. And I'm going to tell you why it's an extraordinary step. Not that it's unprecedented, it's extraordinary, but it is unprecedented in the fact that we did not do that with Richard Nixon. We did not do that with Donald Trump. There was a subpoena, but there was never an attempt to find them in criminal contempt of the Congress or of this committee. It's an extraordinary remedy that's usually reserved for situations where a witness has clearly and willfully defied Congress after extraordinary processes have been exhausted. The majority has not demonstrated that standard so far. I do want to say also that we're in a situation where I don't think that anybody on the Republican or on the Democratic side of this committee is trying to defend former President Clinton. They're trying to find a way to make sure that we're consistent. So the reason we keep hearing the need to have Pam Bondi before this committee is that we're getting ready to bring criminal contempt charges before there's been an investigation. Usually that happens after the investigation. And the notion that somebody is going to come before this committee, Mrs. Maxwell, and take the fifth, I don't care. She's already a convicted criminal. She can't take the fifth. But we can do the actions we ought to be about, and that is to make sure that both of them are before this committee, and then to make sure also, or to suggest, it's up to you and the ranking member, that that meeting takes place and those transcripts are made available, and that Mr. Clinton comes before the committee with counsel so that we then are in a position to move forward. We're taking a big jump here without doing some of the things that we normally do. Now, I'm glad that Ms. Tlaib brought up the matter of victims. She's not here right now, but all of us sat in that room with those victims. It was gut-wrenching, and all of us made a commitment that we would prove that this institution could and would do the right thing. So we're challenged here, Mr. Chairman, and I hope that you and the ranking member can give us a way to proceed here that both of the concerns on both sides are addressed. But if we just move straight as we're going now without an investigation, it begs the question, what happens when the shoe is on the other foot? I yield back.
Gentleman yields back. Ms. Simons next. Before I recognize her, I just want to add, with respect to the Hillary Clinton subpoena, you all voted for that. This committee voted for that in a bipartisan manner. Her name was on that list. And with respect to Pam Bondi, again, she's testifying in front of Congress in less than 2 weeks. Chair recognizes Ms. Simon.
Thank you, Mr. Chairman. Just a quick comment, and I have a friendly question for my colleague, Ms. Luna. And I'll say a friendly question. I've worked with victims for decades. So few opportunities present themselves for victims to sit face to face with folks who hold power, to beg and plead that everyone who had anything to do with their harm be held to account. So few opportunities. I have been a victim advocate where brilliant young women who have been trafficked across this country have stood in courtrooms and were demanded to testify against their traffickers, and they did with such power and grace and fear that their lives may be taken because of that braveness. And a number of those young women that I witnessed take all that they had to confront their demons. They were murdered because they took a stand. And so when we did stand in front and sit in front of those victims and they gave us their all, I hope that this is not the only opportunity, Mr.
Well, thank
Chair,
you very much. And
to
he's a
speak
hell of a guy,
on
but we
their
have
behaff.
an audience. I recognize
From our
so many. I know
president
so many. We have the king of soccer, the king of sports over
To
here. Johnny.
everyone in those
And Johnny,
files,
and I heard you. I just got a report on the sales.
forget
of
all the
tickets.
political
It's,
gains.
There's never been
If
anything like
these
it. So
women
it's good. Gonna break
who are
every record.
connected with the largest
So
sex
thank you for
trafficking
choosing us.
ring
Appreciate that. He's
in
another
modern day
spectacular
American
person.
history
And so many
cannot
people
get
in the
justice.
audience, and
What
you know, I
about
have
the
this beautiful
girls in
speech.
every single state?
Page after page, and I just said, I just
I mean,
made a speech, and
it
they're
is what
all
it
here.
is.
They heard it one way or
That
the
being
other.
said,
And I said, the last thing we want to do
Ms.
is
Luna,
waste our
you
time and
talked
hear it
briefly
again.
about a proposal.
But I do want to say the people in this room are amazing.
She's out.
Most of you
There was a
are in
proposal
the
put
other
on the
room
table
and the
to
United States is
rethink
doing really well.
how we might have a conversation about the
nobody thought
Clintons
was actually
or
possible,
President
certainly
Clinton
not
coming
this
in and
year.
having
It's
a
1 year.
conversation
It's exactly a year if you think
with
about
this
it.
body.
Time flies. It's 25%. It's a long
And I
time.
guess that time has
But it went
passed.
very, very
But
fast. We've had
I know that I
tremendous
would
luck.
love
I
to
think
hear
it's,
from the president of the
been
former
reported by
president
you
of the
people
United
that
States. I would love to hear from the
lovers of
Attorney
Donald
General. I
Trump.
would love
It's
to hear
been
from the
maybe the
current
best
president
first year
of
for any
the
president.
United States.
I think in terms of what we've
The
accomplished, it might
victims
very well be,
deserve
but we've accomplished a lot, including ending
to be
8 wars.
heard.
I have one to go.
The victims
I thought
deserve
that was going to be one of the easiest ones.
for the files to be
It's turning out
released
to
in
be
their
one of the tougher
entirety.
ones, but you
And the
heard
victims
me say
deserve
before,
for
25,
us to
30,000
get to the
people dying
bottom
a month. It's ridiculous.
of this matter.
And I think we're getting close.
I yield back.
Jared's
Well, I actually
here,
would like to
Steve
yield my
Witkoff
time
is
to the
here.
ranking member.
A lot of people that are
Actually,
working
I'm
on that
okay right now on
here
time.
have
I
done a good job.
might come
I
back
think it
around,
could have
but
gone
back to
into a
Mr.
world
Comer and the
where we weren't
Republicans.
here.
Thank you.
It was out of
Ms. Simon.
control. But I think we're going to get it resolved. And I'm doing it to save
Okay.
30,000 people a month, if you can imagine.
Do any other
Kids,
members seek
ridiculous.
recognition?
Your son leaves home, waves to you.
Seeing none,
proud of him.
we are
so beautiful. And then
going
2 weeks
to-
later, he had his head blown off.
There's an amendment at the desk.
Fighting, Ukraine or fighting Russia. It's both of them. The
Well,
total
let's,
are
Ms. Lee,
averaging 30,000. Actually,
what
30,000
purpose do you seek
young
recognition?
people, generally soldiers, a little bit in towns,
I have
but
an
for the
amendment.
most part,
Will the clerk
soldiers.
distribute the amendment to all
Every single
members?
month they're dying.
And
I
the
think
clerk
we're
will
gonna do
designate
well
the
there.
amendment.
But
An
we have
amendment to the
Scott
amendment in
Bessent,
nature of a
who
substitute
everyone knows,
to the
and
William
Howard
J.
Lutnick, and these
Clinton
guys are
Contempt
doing a
Report as offered by Ms.
fantastic
Lee of
job
Pennsylvania.
Without objection, the amendment is considered as read. I reserve a point of order. The gentlewoman is recognized for
They were
5 minutes
both.
to
They were both
explain her amendment.
recommended by
Thank
many
you,
of
Mr.
the
Chair.
people in this room. I said, "What do you think of Scott? Oh, he's
I
fantastic.
think that
What do you
even
think of Howard?" Very
listening
different
to
type. I would
this
say these
debate
are two
throughout our
exact
hearing today, our
opposites.
markup today, I think it's really
And I
clear
like
that at the
that.
heart of
I like
this
that.
effort
They
to
are the
release the
exact
Epstein
opposite.
files
You know, I
are
never thought of
very
it that
real
way. I'm just
human
saying
beings
that. I'm
who have
looking at you
experienced
two. You are in
unimaginable
every way,
harm.
but
They
they're
have been
tremendously
repeatedly
talented
victimized
people.
by the
And very
indifference of the
successful
U.S.
people.
government
And I like
and the
bringing
injustice
successful
that they
people in,
face.
'cause there's a
They
reason for
deserve
success.
peace and healing
It's one of the
and
reasons that
justice.
we've had such
When
success.
my
You know,
motion to
we took
subpoena
over
the
a country
Epstein
with a
files
border that was a
passed,
disaster,
this
with
committee
millions of
resolved to
people
get
coming
that
in. Millions of
justice
people were
for
coming
those
in every
survivors.
single
And I
week.
thank
Literally a
Chairman
week,
Comer
we had
for
millions of
pushing
people,
this
and a
effort
lot of-
forward
and
by
they weren't
issuing
vetted.
additional
Totally
subpoenas
open
for
border.
the
You have
Epstein
people come
estate
in, you could
and the
look at them. I
banks.
don't want to say what.
And we know
how
that
do
without
I
the
define that?
full
Because they always
files from the
discriminate, so I
DOJ,
don't
that is
discriminate.
just not
But,
enough.
you can look at some
That's
people and
why
say
I'm
they're
introducing this
criminals.
amendment, which holds
They
to
want
actually comply with
MAGA
our
to come in.
subpoena.
And we went
Now,
in
oversight
a
Republicans
pretty
might be
quiet way,
happy
as
to
opposed
give
the way
President
we
Trump
did
and
it
Pam
in Minnesota.
Bondi
You know,
a
in
free
Minnesota,
pass to break the law.
We took out over
This committee shouldn't do
10,000
so. This amendment will allow us to go to
people
court
with big
to
convictions
force
that came
Pam
in
Bondi
here
to
that shouldn't be
comply
here,
with our
brought them back.
subpoena
to
and to
countries. In
finally
some
bring
cases, we
Epstein
bring them to
files
jails
to light.
because if you bring them back
I
to the
urge
country,
adoption,
they'll find
and
a
I
way,
yield back.
despite the strong
Yield
borders, they'll
back.
find a way in.
Tampering. We should ask the questions about that. And the idea that some other committee is going to do this is an abdication of our responsibility on this committee, I believe. We should not look. We are the ones that we had the victims sit down in front of us and tearfully ask for justice from this committee. And we promised that. We promised that we would do everything we possibly. We didn't say, well, we'll check with the Judiciary Committee and we'll let them do the work. We said we would take on this responsibility, which is ours, Mr. Chairman. This is the rightful jurisdiction for this case, and we should demand people with evidence to produce that evidence so that we can proceed in our work. We haven't done that thus far. We've let Pam Bondi distort and obstruct the justice that's due to these victims. It's shameful. It really is. And I want to hear from everyone who has a connection to this. I want to hear from every single witness that might be able to provide evidence to this committee. And I think Pam Bondi, with the millions and millions and millions of documents, is at the top of that list. And she has thwarted justice long enough. She is a lapdog to the president. She is trying to protect the president, who is all over this case. And I'm hopeful that eventually he'll be a witness before this committee at some point. With that, Mr. Chairman, I yield back.
Gentleman yields back. Before I recognize Scott Perry, if I may, this committee has done everything that the victims asked that day in that hearing. They asked that we subpoena the estate. We had no idea what was in that estate documents. Could have been all Republicans. Had no idea. Could have been billionaires. Could have been donors to the Republican Party. Could have been donors to the Democrat Party. Had no idea. Without hesitation, I signed that subpoena for the estate. And then with respect to your criticism of Bondi, I don't disagree with anything you said in your criticism of the current Attorney General. And I think she's going to have to answer those questions in front of Congress, in front of the American people in 2 weeks. And I'm confident she's going to be asked those questions, and I expect to hear answers from the criticism that you leveled against her. No one's defending her. Again, we expect to get the documents. They have produced some. We aren't satisfied with the pace, and she's going to be in front of Congress in 2 weeks to answer that exact criticism. Chair recognizes Mr. Perry from Pennsylvania.
Thank you, Mr. Chairman. I appreciate the opportunity to address the unjustified and cowardly claims made against me by members of this committee after I left, and maybe they were afraid to face me while I was here, but I'm here now and I'm going to face you. Just to be clear, if you have this job, you should know that any subpoena from another Congress is invalid in the next Congress. It dies with the last Congress. That's minimum information that you should know if you're going to serve in Congress. So just let me inform you of that if you didn't know that. Regarding the so-called subpoena, it is unjust and it is immoral to get a group of your friends together who have a predetermined outcome, put them together in a room, and then use the power of the federal government to prevail on your political enemies. The subpoena that was served to me or my counsel was not valid because there was no valid committee serving it. I did not violate any law, and I reject the claims or the appearance that I did. The Democrat Party sought to, by use of the awesome and just the grand power of the federal government, to destroy my reputation as a person who was not charged with anything, was not accused of anything, was not the target of investigation. You wish to dirty me up and bankrupt me so you can get rid of me. It is outrageous, and I have not mentioned that at all, but since you brought it up,
But since you brought it up, I felt it was appropriate at this time to clear my good name. And as the years have gone by, more information has come out to prove what I just said was absolutely accurate. What happened during that period of time when you were in the majority was you set up a star chamber with predetermined outcomes and then sought to destroy in any way possible your political enemies by fashioning lies and then repeating them over and over again, which you do to this day, which you do to this moment. Now, when I spoke earlier, I didn't mention the subpoena. I mentioned the truth, and that's what this committee should be all about, wherever it comes from and whoever it touches. And I believe that to my soul, which is why I have been on this bandwagon long before you have ever been on it, and much more than you have ever done. Much more than you have ever done, legitimately and sincerely. So I thank the chairman for allowing me this opportunity to set the record straight. And hopefully, that won't happen in the future. Now, regarding the Clintons, as you know, I offered the amendment, the resolution, to bring everybody in, attorneys general from both sides of the aisle. But with the Clintons in particular, because of their particular knowledge of Mr. Jeffrey Epstein and his exploits with underage women. It is horrific. As a father of two young daughters, I would just say that the perpetrators of whatever happened ought to be thankful that their fathers don't know about it. But I sure hope that they do know soon. And I sure hope that there is justice for all the victims and that we don't seek to destroy the lives of those uninvolved for political purposes, which is what, quite honestly, this whole theater, this whole charade has been about. This should have been easy. Is Mr. Clinton an American citizen? We appreciate that he was the president, but according to his wife, he's not above the law, and neither is she. This is a lawful subpoena with plenty of time. The committee has been, and the chairman has been more than generous trying to work it out. But it's pretty obvious to anybody with eyes in their head that the Clintons feel like they're above the law and they're going to get special treatment, as Secretary Clinton did the last time she was subpoenaed. I'll remind everybody that she worked out a deal to come in with her so-called attorney, but was her aide behind closed doors on a Saturday without any transcript. That's where we're headed. I'll yield the balance of my time to the gentlelady from Colorado if she wants it.
Thank you, Mr. Perry. I just think that all of this is rich. I mean, we have every Democrat here just with their typical talking points, claiming they want to hold the Clintons accountable and hear from them. So I think it's time we move on and get to the actual point of this. We had the Clintons defy a lawful subpoena, and that is what we are here to discuss. But Democrats want to bring up anything but that. And if this continues, I'm going to call the question. So continue with your Clintons and how you are going to protect them or defend them, or I'm going to call the question, we're going to have the vote and end all of this nonsense rhetoric that's going on. Mr. Chairman, I yield.
Gentlelady yields back. Chair recognizes Ms. Stansberry's next on the list, I think. No? Okay. Frost, who's next? I just go by what the ranking member wants. So who's next? Mr. Frost from Florida.
I just want to speak in support of this amendment that has been put forth by Representative Lee. Look, at the end of the day, the United States Congress voted damn near unanimously. One member of Congress voted against releasing the Epstein files, happens to be a Republican on this committee, but damn near unanimously, we said we want the files. Months before that, in a subcommittee on this committee, we said we issued a subpoena for the files as well. They have failed to comply with the law, not just on one law that we passed, but also on a lawful subpoena that this committee put forth. And so I just want to speak in support of Representative Lee's motion here, an amendment here, because we have to go at this everywhere. We want to hear from everyone. We want to hear from former president. We want to hear from anyone who's implicated. We want to hear from anyone who has information that might help us get justice for the victims. But it is obvious that my Republican colleagues are doing anything they can to play defense for the administration. 1% of documents is unacceptable. 1% of documents is unacceptable when you've had months and months and months since June or July of last year to produce these documents when we sent a lawful subpoena to the Department of Justice. 1% of documents is unacceptable for a bill passed by the United States Congress that they are in violation of. They're breaking the law right now as we speak. And all we're asking for is accountability here for everyone. And so this amendment, I think, is very simple. I know the chairman keeps bringing up the fact that Pam Bondi is going to come to the Judiciary Committee. The Judiciary Committee is not the committee that is leading the investigation on this. We are the Oversight Committee. And so she can go over to the Judiciary Committee all she wants, like she, by the way, is supposed to, like every other attorney general has in the history of this country. Shows up before the Judiciary Committee at least once a year or once in Congress to talk about a lot of different business. But we have a very specific thing we need to talk with her about. And it is talking with her about the fact that she is breaking the law and that the administration is obviously slow rolling, putting forth the Epstein files. And I do not buy this thing that, oh, well, they're taking their time to redact it and this and that. We all know that's a load of BS. We all know that that is a talking point that perhaps the administration gave some of my colleagues that they are just repeating over and over and over again. But when you have the entire Department of Justice or a lot of people working on this, you should be able to produce documents in a much faster way. And the law was clear. And by the way, it's the law that we all voted on. So if you thought that the timetable was unfair, you should have voted no. But you voted yes. We all voted yes, except one. And so I think this is a very sensible amendment that everyone should vote yes on. Because it is important that we have accountability across the board, no matter who you are. I will yield. You want my time, ranking member? I'll yield the balance of my time to the ranking member.
Thank you. Thank you again, Mr. Frost. Just to conclude, we obviously have and support Representative Lee's amendment. We think it's important. It's important to get Pam Bondi to actually produce the files. And it's certainly important to move this debate forward. And so I just, again, want to reiterate and reinforce our support as we wrap up this debate on this amendment. And so thank you, Mr. Coomer.
Thank you. We have one more speaking request on our side. That's Mr. Biggs from Arizona.
Thank you, Mr. Chairman. And turns out, apparently, I was mentioned as well. When I was conducting that hearing that on Minnesota fraud and other fraud that the Democrats were so interested in that only 2 of them bothered to show up. That was interesting. Well, so let's talk about the illicit subpoenas, because I think some of my colleagues may not remember this, but the resolution that we all passed, that passed out of here to install the J6 committee, gave to then Minority Leader Kevin McCarthy specific authority to name the members from the Republican side that would sit on the J6 committee. So he named them. But Speaker Pelosi didn't like those guys. So she said, no, they can't be on the committee. So she booted them and replaced them with people that she felt would be more amenable to accomplish the desired political outcome that she wanted the J6 committee to have. And that was, so she put 2 individuals, you will remember Liz Cheney and Adam Kinzinger on there, having removed, and no other Republicans were on there. And so not only did she violate the resolution, but the resolution all called for a certain number to be on there, and there were not that number. So the committee itself was illicit. It was not a standing committee like this is, where you have jurisdictional authorities. That committee, by that point, was no longer a committee. It was an effort to railroad people, including myself. And things have been said about me repeatedly that have been debunked. Everything's been debunked that was said about me. But here we have it today, and Mr. Perry was right. This was designed to go after certain specific people. I'm still not quite sure why I was one, but I was one. And bringing it up today is actually kind of an abhorrent tactic because it was an illicit committee, didn't have authority to issue an illicit subpoena, whereas this committee issued a legitimate subpoena. Not only did it provide the subpoena, but it actually worked for months trying to get the Clintons and accommodate their schedule, including continuing this at least once so the Clintons would find it more convenient to come and respond to the deposition. Leaving all other deflection aside, if you really want the Clintons to come in and answer these questions, then this would be the appropriate time to vote to hold them in contempt. And with that, Mr. Chairman, I yield back to you.
Gentleman yields back. The question is now
Mr.
on
Chairman.
the amendment offered by Ms. Lee from Pennsylvania.
Mr. Chairman,
Okay.
if I might,
Go ahead.
so that we know exactly what we're doing here, because this has gone way off of where we started with Ms. Lee's amendment. So that members of the committee know, this resolves itself that the Committee on Oversight and Government Reform shall initiate judicial proceedings in any federal court of competent jurisdiction on behalf of the Committee on Oversight and Government Reform to seek declaratory judgments affirming the duty of Patricia or Pamela J. Bondi, Attorney General of the United States, to comply with the subpoena duly issued to her by the chairman of the Committee on Oversight and Government Reform as a part of investigating and the investigation into federal government's enforcement of sex trafficking law generally and specifically its handling of the investigation and prosecution of Jeffrey Epstein and Ghislaine Maxwell. How we vote on this will be very telling. I support this amendment. I would urge other members of the committee to do so also, if we are serious about equal practice and holding everyone accountable. I yield back, sir.
Gentleman yields back. The question is now on the amendment offered by Ms. Lee from Pennsylvania. All those in favor of the Lee amendment signify by saying aye.
Aye.
All those opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not.
Recorded vote, please, sir.
A recorded vote is ordered as previously announced. Further proceedings on the question will be postponed. For what?
Mr. Chair, I have an amendment at the desk.
The clerk will distribute the amendment to all members. The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute to the William J. Clinton contempt report is offered by Mr. Min of California.
Without objection, the amendment is considered as read. I reserve a point of order. The gentleman from California is recognized for 5 minutes to explain his amendment.
Chair Comer, I motion to amend your amendment in the nature of a substitute to authorize the House Oversight Committee to do 3 things. First, pursue federal court action to enforce a subpoena against former President Bill Clinton related to the sex trafficking investigation. 2, require the committee to report back any resulting litigation. And 3, direct the House General Counsel to represent the committee with the Speaker's approval. Now, I have, as mentioned previously, spent my career trying to enforce the rule of law. I started as an SEC enforcement attorney, went on to become a law professor. I very strongly believe in the rule of law. But the rule of law is not just about not having anyone above the law. It is also about not targeting people simply because you don't like them, or because they're in a different political party, or because they've done things you don't particularly care for. Going after an individual uniquely because of how they're positioned is also a gross violation of our powers and of the rule of law. And if you look at the precedent of how Congress has operated, we have 3 inherent powers when it comes to contempt. Inherent contempt, civil enforcement, and criminal contempt. Now, since we initiated criminal contempt back in the 1930s, we have rarely, if ever, used criminal contempt as a charge, and we have almost never leapt from civil enforcement to criminal contempt. The decision here to go from civil enforcement and to ignore that step, jumping to criminal contempt, is, in my view, a gross imposition, a gross abuse of power on our part. It is also counterproductive because if we launch criminal contempt proceedings, I think my colleague Mr. Biggs pointed out that we want the Clintons to testify. If we launch criminal contempt proceedings, we will not hear from the Clintons. That is a fact. They will be tied up in court. We have no guarantee that they will ever testify before this committee. Civil enforcement will achieve the goal we want of getting the Clintons out here before this committee. Now, I just think this is problematic. We talked earlier, Mr. Comer, and I still have not heard you to this point in time say anything about the Clintons defying the subpoena. I've heard you say obfuscate, delay, drag their feet. We've had 5 months. But at no point in time did they say we're not complying with the subpoena. And to me, civil enforcement is an appropriate intermediate step. It makes sense because it allows a court to step in, secure compliance with the committee's subpoena in a nonpartisan, orderly way that follows the rule of law. Court would be empowered to impose fines and actual imprisonment if the individual or entity refuses to comply with us. If we break from precedent, this is going to start potentially a chain reaction of partisan warfare with criminal charges. That is not a road I believe we want to go down in this committee or in this Congress. I think civil contempt will achieve our goals, and it will do so in a way that is consistent with the rule of law. With that, I yield back.
Gentleman yields back. I'll recognize myself for a few minutes. The committee's consulted with the House Office of General Counsel as well as committee counsel, who have expressed significant concern with shifting from criminal contempt to civil contempt because it would likely result in extended litigation that would go beyond this term. As Mr. Perry said, a subpoena is only good for a congressional term. He is already 5 months past his subpoena. The Clintons have lawyered up. There's no question in my mind that if we do this, they will ride this out and hope that the House flips and that you all are in control and you all just let them get by without answering any questions, which I think is terrible. So I cannot support this amendment. I ask my colleagues to oppose this amendment. Chair recognizes the ranking member.
Thank you, Mr. Chairman. I want to support the amend motion. I just want to reiterate something I think all oversight Dems have said today is that we all want to hear from President Clinton. We all want questions answered from President Clinton. I don't think one member of this committee has stated anything differently. And this amendment is a way for us to secure compliance without immediately moving to criminal contempt while they have been trying to negotiate answering our questions. We can continue to let the legal process play out. Both the integrity of our investigation as a whole is critical as we move forward. This is an opportunity for us to get our questions answered from President Clinton. We will do that without empowering a Department of Justice that, quite frankly, has been corrupt and untrustworthy for many, many months. We should continue to negotiate and work through an established process. Clearly, there's interest to negotiate from the Clinton side. Let's hear from President Clinton. Let's support this motion. I yield back.
If I may, and with all due respect, if you want to hear from President Clinton, have him come in for the deposition. They've had 5 months to do that. For whatever reason, you've been unsuccessful. There's 2 more weeks before this will be voted on for the full House. We will hear from Bondi in between, and we will go from there. We expect to hear from Bill Clinton. He's not above the law. Mr. Walkinshaw is recognized.
Thank you, Mr. Chairman. A couple of points. One, it seems to me like we made some progress in the negotiation to talk to President Clinton here today. You have acknowledged you and your team are no longer going to demand to be able to ask questions not related to Epstein. The Clintons have agreed to transcription of that conversation. So you could go to New York and talk to President Clinton on the date that you all set. That's ready to go. We've heard from Ms. Luna that it would be a bad look for you and the ranking member to have to drive to New York. They got airports there. You all could take a flight and go to New York and have the conversation. That would move our investigation forward. I'm supporting Mr. Menn's amendment in the nature of a substitute, and you know, I'll share, I was a staff member for a member of this committee for more than a decade throughout the Obama administration, multiple chairmen of the committee, and time after time after time, Republicans who chaired the committee, Democrats who chaired the committee, negotiated with members of the administration or private individuals who they wanted to have come before the committee, negotiated the terms. Not once did I see this kind of leap to criminal contempt. It is not consistent with the way that this committee has operated. It is not necessary. Mr. Min's amendment, or you and the ranking member going to New York and having the transcribed under oath conversation with President Clinton would move our investigation forward. Either of those are better options than pursuing criminal contempt, which would not get us a conversation with President Clinton, would not move our investigation forward, and would not get the survivors the transparency that they're demanding. Thank you, Mr. Chairman.
If I may, Mr. Walker, to reply to that, one reason that your counteroffers today don't hold a lot of weight with me is the fact that we never demanded to their attorneys that we ask questions outside the realm of the Epstein investigation. That was never a thing. They have just made that up. So their dishonesty, we've already admitted one lie when they said this wasn't a lawful subpoena. That was in the letter from Bill Clinton and Hillary Clinton to me. They said this is not a lawful subpoena. It is a lawful subpoena. Does anybody disagree with that? It is a lawful subpoena. So number two, we've never asked to ask questions outside of this. And I'll give you an example. When we were negotiating with Hunter Biden's attorneys, or judiciary was negotiating, we agreed when Hunter Biden came in to talk about the Biden influence peddling and the money that they were receiving from foreign countries, we wouldn't ask about the stuff on the laptop. We wouldn't ask about the stuff in the suspicious activity reports about human trafficking and other things with Hunter Biden. We only asked about the influence peddling, which was what the investigation was. And it's been the same with the Clintons. So if their attorneys are trying to spin out with the media that we wanted to talk about Monica Lewinsky or anything else, that is not true. All we want to talk about is Epstein. That has always been the deal. And for them to say otherwise is a complete 100% lie by the Clinton attorneys.
Well, I'm glad to hear that, Mr. Chairman, and I'm glad that the Clintons have agreed to have the conversation transcribed. So it seems to me that the only remaining barrier of the barriers you have identified is you don't want to go to New York. And from my view, this investigation
I'm going to New York this weekend.
Enough.
That's not a barrier.
Go to the moon. Let's have the conversation. You can do it.
Chair recognizes who's next. Ms. Stansbury.
Thank you. Honestly, I just want to get some clarification because I've heard so many different things here this morning. So, Mr. Chairman, you just said you're willing to go to New York. In fact, you're going to New York this weekend. Is that correct?
The committee has released the emails, so
no,
you can see the communication between
I'm not trying
that.
to be difficult. I really just want to understand. Are you willing to go to New York to conduct this interview and deposition?
With the committee, with the staff, it's not going to just be. We have negotiated this for 5 months, Ms. Stansbury.
No, I'm just asking simple
and you're
questions.
all
So
are
the
thinking,
question,
and they've had 5 months.
So is the answer a yes? It sounds like it's a yes. My other question for you is, so it's my understanding that you guys have received both correspondence by phone, email, and from a written letter from the attorneys from the Clintons offering to do this on the record with you, with the staff, with the attorneys. Is that correct?
I wasn't paying attention to your question.
Okay, we're here pursuant to a motion you brought for contempt, and the claim is that you have made reasonable accommodations and that they have not been responsive, but they have transmitted correspondence to all of the members of the committee, including yourself and all of the members, basically including a letter from their attorneys stating that they have offered by phone, that they have offered by email, and they have offered in a written letter from both themselves and the attorneys to meet with you on the record with the staff to give sworn statements. Is that correct?
We have negotiated for
yes
5
or no.
You all are trying to create a false narrative. You've had 5 months. You should have gotten to the Clintons before the contempt vote.
All I'm asking you is if that's true.
And if they weren't losing public opinion, Ms. Stansbury, they would be defined this now. That's the only reason there's negotiations at the last minute.
But Mr. Chairman, I'm just asking.
They don't get to make the rules. We make the rules. The chairman of the committee, we make the rules.
But Mr. Chairman, is that the fact? That's all I'm asking. Is that factual? Just to be clear for the public, his staff are advising the chairman to not answer that question. Okay.
No, the staff said they couldn't understand what the hell you were saying because you've blabbered for 3 minutes, but go ahead.
Okay, Mr. Chairman, let me say it again. Is it true that the Clintons and their attorneys have had multiple conversations with you via phone, via email, and via written correspondence offering to give sworn statements on the record to you and the staff? Just a yes or no.
The Clintons said that we could take notes, Mr. Garcia and I.
But
the committee would like to ask questions as well.
Are you not in receipt of a letter postmarked from their attorneys yesterday saying that they would give sworn statements under oath?
Sworn, that's not a record.
You're not in possession of the letter that their attorneys sent yesterday to the entire committee.
What their letter is stating isn't what you're stating.
Okay, well, I'm not going to read the letter. We'll make sure it's available to the public.
Although I'm sure they'll make sure anything's available to the public. The problem is they've not been truthful. And
but Mr. Chairman, the legal standard for contempt is non-cooperation. And so my question to you is, are you making reasonable accommodations? Are you cooperating? Are you in correspondence with them? And this is in direct relation to the motion that was made now for an amendment that essentially would use our civil compliance code in order to get full compliance from the committee. And you're saying you're opposed to it because they haven't complied. But I have not heard you lay out the case for compliance. So why would you oppose civil compliance?
Ms. Stainsbury, we've been negotiating for 5 months. In the meantime, every other person has complied with the subpoena that we've dealt with.
That's not the legal standard for the court, Mr. Chairman. Okay. Well, I see we have a lot of armchair lawyers here. I am not one, but Mr. Min, I do support your amendment, and I think that while the chairman refused to answer questions on the record, I think we established that there has been ongoing correspondence and that it does not meet the standard.
Ms. Simons, recognized.
I would like to yield my time to the ranking member.
Thank you. I just want to clarify 2 things. The first is in the comments, I know, Mr. Chairman, you had just discussed about not going beyond the scope of the Epstein investigation with questions. To be clear, though, during the Bill Barr, that you were not interested in, during the Bill Barr deposition, you did go beyond the scope of the Epstein questions. You asked questions about Russia and a bunch of other things. And so that has been that testimony was public. That has been a pattern that has been in the public realm. And so the reason the Clintons have pushed back on that is because you actually have gone beyond the scope of the Epstein investigation in depositions on this investigation with folks you have subpoenaed. I just want to be clear about that, because you just mentioned that right now in your comments. And the second thing I want to say, just to Ms. Stansbury's point, to reiterate, is regardless of when it was done, it's false to say that the Clintons haven't agreed to a transcript of the deposition. They have agreed to a transcript. They've done it and they've reiterated that position in an email that they sent today. It's a position they've made before.
Today.
To position, sir, I mean, obviously, to position that they've made before to your team. It's a position that they have made a few days ago. They've publicly said it in the press. In fact, it was covered, I think, today or yesterday in an article in the New York Times. And they again reiterated it during this testimony when you said that they've not agreed to. They've clarified their position. They are willing for it to be transcribed. I just want to clarify that.
Chair recognizes who's next.
I still have time.
Okay.
If that's okay, Chair, I would like to use the remainder of my time and yield it to Representative Min.
Thank you, Rep. Simon. I just want to add a couple points here. First, I just want to note something that I think has been a little bit conflated today. This vote today on the contempt proceeding is not about whether Bill and Hillary Clinton were involved with the Epstein sex trafficking ring. If either or both of them were involved, they deserve to be prosecuted to the fullest extent of the law. The survivors deserve justice. But the vote that we are about to take later today is about whether the Clintons' actions in negotiating through their lawyers on the particulars of how, when, and where they might appear before this committee, whether that constitutes a willful defiance, and that is the legal standard, a willful default of the subpoena issued to them. And again, I want to point out that Chair Comer has repeatedly talked about negotiating for 5 months, delaying and trying to run out the clock. I do not believe that that is willful defiance of the subpoena. That's not just my opinion. It's the opinion of every serious lawyer in this space that I've talked to that actually